Now, today we're going to be talking about a development in a case called Rupp v. Bonta. This is a challenge to California's Assault Weapons Control Act, and we've recently suffered what probably would be described as a temporary loss on this particular case. Now, whether or not you live in California or within the Ninth Circuit, this case is kind of important because it shows us how the anti-gun judicial community is trying to attack the Second Amendment, or more specifically, too, how the different states are trying to abrogate our rights as it relates to the Second Amendment, specifically now in a post-Bruin environment. I do believe that they are ultimately not going to prevail on this line of thought because it reaches some sort of bizarre conclusions if we are to follow it to its logical extreme. But that being said, this is the card that they're playing, so it's important that we understand how the other side's logic actually works. All right, so a little bit about Rupp and another case that you might have heard of called Miller v. Bonta. Both of them are essentially identical. Originally, the California Rifle and Pistol Association filed a challenge to California's Assault Weapons Control Act called Rupp v. Bonta. This case was filed in Judge Stanton's courtroom. Now, a little bit about Judge Stanton. She is an Obama appointee, and from the looks of it, is pretty antagonistic towards the Second Amendment. And she is, I think, arguably, based on her writings and her career, the absolute consummate collectivist. She believes that power emanates from the state, not from the people. And her judicial conclusions seem to be consistent with that. That being said, there was another case that was also challenging California's Assault Weapons Control Act. That case, Miller v. Bonta. That case was heard before Judge Benitez down in San Diego, who, not surprisingly, came to an entirely different conclusion than that of Judge Stanton. Now, Miller was decided before Rupp. And of course, the state has appealed St. Benitez's decision down in San Diego, essentially finding that the Assault Weapons Control Act is completely in violation of the Second Amendment. That case is now before the Ninth Circuit, where it will be reviewed. And that's not a guarantee, by the way, that the Ninth Circuit is going to overturn Judge Benitez. In fact, the makeup of the Ninth Circuit has changed pretty dramatically over the years. It's now about 50-50. All right, we've got about 50% of the judges that sit on the Ninth Circuit actually hold some level of fealty to the Constitution. About 50% of them are completely off the page. They are what we would like to call outcome determinative jurists. They have policy guidelines that do not seem to be constrained by the confines of the Constitution. Few years ago, that group of collectivists that sat on the Ninth Circuit pretty much dominated the Ninth Circuit. That's one of the reasons why the Ninth was oftentimes being called the most overturned circuit in America. They would essentially completely disregard the Constitution and come up with their own rulings that generated policy decisions that they wanted to push through. And then, of course, the Supreme Court would overturn them. That, like I said, is not necessarily the case anymore. It's about a 50-50 split. Well, as I said, Judge Benitez found that the Assault Weapons Control Act was unconstitutional in Miller. And then last week, we got a decision in Rupp, where, unsurprisingly, Judge Stanton found that the Assault Weapons Control Act is perfectly constitutional. I don't see what your problem is, counselor. Well, she made a number of massive errors in her analysis, and I do want to go over those. And yeah, they'll probably ultimately be overturned on appeal. The first thing that she did is what the state has been doing and has been bugging the crap out of me since they've started, and that is using the common use test to make a determination as to whether or not a specific piece of hardware falls outside the scope of protection of the Second Amendment. Remember, using Bruin as a constitutional test, the threshold question is to find out whether or not the statute in question violates or abrogates someone's Second Amendment rights. Once that has been determined, then the burden shifts to the state, and the state has to show that in order for the statute to survive constitutional review, the state has to show how this law is consistent with our nation's history, text, and firearms regulatory traditions as existed in 1791 during the ratification of the Constitution. There is an argument, I don't think it's a persuasive one, but there is an argument that a secondary time frame during the ratification of the 14th Amendment, when these fundamental rights became essentially incorporated into state constitutions, should also be a time frame where you look to see whether or not there were relevant statutes, okay? Irrespective of that, it's either going to be exclusively around 1791 or it's going to be 1791 with some degree of extra regulations that could be looked at that come around 1867, 1868. Irrespective of all of that sort of analysis, a statute that was generated in 2014 is absolutely going to be outside the scope of review. So, in any event, the state has been making the argument that we shouldn't even get to the history, text, and regulatory tradition standpoint because all of these challenges, the plaintiffs have not shown how their Second Amendment rights are being abrogated. In a hardware test like this, Judge Stanton is saying, well, assault weapons, and I use air quotes, of course, when I say assault weapons, because to be quite frank with you, I have no idea what the hell that's supposed to mean. But that notwithstanding, assault weapons are not protected by the Second Amendment. It's that simple because they are dangerous and unusual. Now, this is her first major mistake. We'll go into that in a little bit more detail. Her second mistake is to say that the relevant statutory period to be looking for laws regulating certain pieces of hardware is not to be 1791. Instead, it is actually to be at the time of the ratification of the 14th Amendment. And specifically, she looks at Bowie knives as being analogous to AR-15s. And I'm sure everyone can see the consistency on that. In any event, I want to talk about this common use argument because it's being bandied about quite frequently. So in Heller versus the District of Columbia, Justice Scalia, writing from the Supreme Court in that, incredibly important decision, said that there are certain pieces of hardware that do in fact fall outside the scope of the Second Amendment. These are weapons that are dangerous and unusual. That's an important distinction because then we have to ask ourselves the dangerous aspect, that's pretty easy, okay? Most weapons, if not all weapons, are by definition dangerous. It's that secondary component, unusual. Okay, so what makes a weapon unusual? Well, if it's not really widely adopted by the marketplace, that certainly is an example of unusual. But the other aspect that the courts have been grabbing onto and the states have been grabbing onto is that the weapon is not being used for lawful purposes such as self-defense. This is a direct quote from Justice Scalia. Second Amendment protects weapons that are in common use for lawful purposes such as self-defense. Critical word, such. It does not say for lawful purpose of self-defense. It's a non-exhaustive list. There are other lawful purposes beyond self-defense, one of which, is target shooting or hunting, or there's a variety of different types of activities that don't directly relate to self-defense. In any event, this court, Judge Stanton says, no, the exclusivity of the Second Amendment protects weapons that are in use for self-defense. Now, little sidebar for a second. The language that we use today is different from the language that we used at the time of the ratification. The Second Amendment says that the core purpose of the Second Amendment is resistance to tyranny. Now, many people today would look at resistance to tyranny as being some sort of, fear of an over-oppressive government or an occupying military force or something like that. That's fair. That's a legitimate, understanding of resistance to tyranny. But resistance to tyranny in modern parlance would be self-defense. Right? You are defending yourself against a criminal. You are defending yourself against an abusive spouse. You are defending yourself against an oppressive government. Some tyrant, and tyranny comes in all shapes and sizes, some tyrant that is attempting to use force to compel you to engage in an act that is against your will. It's a very definition of tyranny. Whether or not it's state-sponsored or criminally induced is irrelevant, okay? Tyranny is a broad concept, and the Second Amendment is designed to allow us to exercise our God-given rights to resist tyranny. Okay, cool. The court is saying, no, only weapon systems that you can empirically see are being used for the specific purposes of self-defense are covered by the Second Amendment. Well, that's just factually inaccurate, okay? Above and beyond that, there is one phrase that appears only one time in the Constitution: shall not be infringed. Infringement is a much broader concept than simply Congress shall make no law, right? If there is an admonishment in the Constitution that says this particular area is, off the table from a policy standpoint, you cannot make a law that prevents somebody from engaging in free speech. Okay, well, that's pretty consistent. That's a direct limitation on what the Congress can do. But infringement is a much, much bigger concept. Yes, you may not necessarily be creating a law that prevents somebody from acquiring a weapon. However, you may be creating a law in a totally unrelated area that creates a number of burdens that prevent people from quickly and easily being able to access a weapon. That would be infringing on their rights. The framers saw that the Second Amendment, that the right to bear arms, was incredibly important. In fact, arguably speaking, the single most important part of the Constitution, because it fundamentally acknowledged that power originates with the people. It's not some sort of, granting by government, okay? Well, collectivists are completely antagonistic towards this idea, and Judge Stanton falls squarely in this. So she says, no, assault weapons, again, whatever the hell that means, assault weapons fall outside the scope of the Second Amendment because they're not being used for self-defense. Well, this argument would also suggest that .30-06 bolt-action hunting rifles are also outside the scope of the Second Amendment, that lever-action rifles are outside the scope of the Second Amendment. that, stun guns are outside the scope of the Second Amendment. Unless you can show, based on her theory, that this particular platform is being used empirically on a regular basis for self-defense, then it falls outside the scope. It's sophistry, okay? She completely fails in this argument, and ultimately, I believe, will be overturned as a result of this. Again, she then looks to see what relevant statutes. She actually does go through the historical analysis, but rather than limiting herself to originally 1791, she looks, as I said, to these Bowie knives, and she says a Bowie knife was regulated by various states because they had a singular purpose: to kill as many people as possible, completely missing the point that the simple presence of possessing a Bowie knife might have dissuaded a criminal from attacking you. That's utterly irrelevant, okay? The Bowie knife only had one purpose, and that's to kill someone, and the AR-15 has a singular purpose, and that's to kill as many people as possible. Again, pure sophistry, factually inaccurate, but, this is what you get. She is, again, outcome determinative. Like I said, I believe this case is going to be overturned. This was a ruling that she gave granting summary judgment to the state of California, essentially killing the case prior to it actually going to trial. It will now be appealed to the Ninth Circuit, and as I said, will most likely be overturned, whether at the Ninth Circuit or at the Supreme Court level. Now, there's a variety of judicial decisions throughout the country that essentially are mirroring what Judge Stanton said. And either this one or one of them will be making their way up to the Supremes. Ultimately, we'll be getting a ruling on that. And I believe, like I said, it will be overturned. All right. With that, if you have any questions, you can certainly email me at stephen@artemishq.com. And as always, I want you to train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.